Three more matters today, madam. Similar matters, madam. Or similar.
50,
55 and 56. Transfer matters, madam.
55 and 56.
Yes, madam. Similar to them, madam.
Why not on Friday?
Not they'll be released by tomorrow, madam. For today itself. That's all.
All right.
If the lordship.
May I please, Lordship, item number 5, Lordship, supposed to file one additional affidavit. They have filed it. Can it be taken up day after?
Monday. Item number 5.
5.
Mr. S.P. Chaudhary, counsel for the petitioner, submits that the additional affidavit required to be filed by him has been filed today. Accordingly, that the matter be listed on Monday, registry to connect the affidavit stated to be filed along with the case record. And this the matter on Monday.
May I please, Lordship? I
Yes.
think to mention number 18, Your Lordship, for orders.
18.
Here, Lordship.
Yes.
That the matter may be adjourned for the day and come up after 2 weeks, Your Lordship, because the government has filed affidavit and we file a counter affidavit.
Counsel for the petitioner prays for 2 weeks' time to file rejoinder. Prayer made is allowed. It's after 2 weeks.
Date may be fixed, Lord.
You file your rejoinder, then make a prayer for fixing a date.
May I please, Lordship, for statement, for orders for IA for typographical
All right.
error.
May I please, Lordship. Lordship, I am praying for listing a matter in orders column, Lordship. Matters.
1 minute. Take it over to other side of Yes.
Lordship, I am praying for listing a matter for orders column, Lordship.
Orders column. Orders Monday.
Lordship.
Next week, Monday.
Product matter was fixed today, my lord. It has not been listed. Friday, Monday.
Not Friday, it can be tomorrow. Parthard,
Product.
tomorrow.
Apply.
May I please, my lord. Sir, you mention a matter for listing a pending arbitration. Need a convenient. Section 11
For admission.
for admission. Respondents have appeared.
Tomorrow.
I'd like to mention for listing this case, my lord, this is regulation civil matters is given there. So this pending matters, any date, my lord.
When any date? 19th.
19, my lord. Obvious.
I wait for admission.
Admission 19th.
I'd like to mention item number 11. My senior counsel is unable to appear today.
Item 11. When do you want it?
Lordship, matter may be fixed.
Item 11 on the request made by the counsel for the petitioners is passed over to be listed next week.
Maybe 20, my lord. I'm sorry, 19. 20 or 22.
22 is not possible. It will be on 25.
Fine.
Yes.
May it please your lordship. I beg to mention item number 20.
20.
In the last occasion, we took time to file affidavit in reply. But as a deponent is unwell, so the affidavit could not be made ready.
How much time you want?
Your lordship, 14th or 15th of September may be fixed for the next day.
The request made by the counsel for the petitioner matter stands out to be listed on 14th September.
Right.
The submissions made by the
My
counsel.
lord, may I please, your lordship, my lord, here, my lord, two petitions, my lord, by the same petitioner on two different issues, my lord. Item number 58 is instructed, my lord. It may be withdrawn, my lord, but 59 will remain.
You mentioned for listing both the matters.
But it was earlier already connected, therefore it has come, my lord. But I paid withdrawal for 58 only.
It is submitted in item 58 WPC 2253.
Yes, my lord.
Is submitted by the counsel for the petitioner. The writ petition is the practice. Petition may be closed, considering the submissions made. And no objection is raised by the counsel for the respondent. Writ petition therefore stands dismissed on withdrawal. Pending IAs are also dismissed. interim order if any is vacated. So and so appears for the respondents. Item 59 submitted that this writ petition was connected to WPC 2253 and therefore was listed. The petitioner wishes to pursue the claim. Said writ petition accordingly the same be listed after a week.
Deeply.
The arbitration petition under section 11, Lordship.
You are supposed to file something.
Yes, Lordship, I filed, Lordship. It is page 199 is the arbitration clause, Lordship. The additional affidavit,
199.
199. Clause 70. All dispute between the parties to the contract other than those which are or any other person is the contract expressed to the final and buildings shall after written notice by either party to the contract to the other of them be referred to the sole arbitrator of an engineering officer, Lordship.
Where is your notice?
Yes, Lordship. Notice, Lordship. Page 166, Lordship. 160, Lordship.
160.
In the writ petition, Lordship. Annex 11. Dated 14 October 2023.
All right. Heard counsel for Mr. J.K. Goswami. Counsel for the petitioner issued notice. Return number 4 weeks. Steps on the respondent by speed post within 1 week. Matter be listed after the returnable date.
Lords. Date may be fixed, Lords.
It will come after
Lords,
return.
Lords.
Yes.
Manoj, it's a section 11 petition.
Where is the clause?
Manoj, it is in page number 94, Manoj. I have also reproduced in the para 2 also, Manoj, it's clause number 29.
94.
Manoj. Manoj, settlement of dispute and arbitration. Manoj, may I read?
Any notice was issued?
Manoj, the notice was issued. Manoj, the notice is on page number, Manoj, 198, annex to 22, Manoj. It is notice dated 11/2/2026. Section 21 notice was sent, Manoj.
Yes. Heard. You are Mr. Banerjee.
Arijit, Manoj.
Arijit Banerjee appearing for the petition.
Miniti Kumari, Manoj.
This is an application assisted by MSN. It's an application under 11(6) of the Arbitration Conciliation Act 1996. Issue notice, returnable 4 weeks. Steps on the respondent. Any standing counsel? MS R. Bora appears on behalf of the respondents. Since the respondents are represented by the standing counsel, notices are waived. However, extra copies be furnished within a period of 2 weeks. Matter be listed after the returnable date. The respondents may file their objections if any. Yes.
Made, please, Millets. Millets, the GCC, which talks about the arbitration clause, page number 119, Millets. Read with, it should be read with, Millets, at page number 137, SCC.
Yes.
And Millets may have notice at page number 267.
Heard, Mr.
Satendra Manitrapati.
Lordship, here Karve Anglong is the necessary, it is between Karve Anglong and the petitioner. Lordship, Karve Anglong council has not been made a part.
Where is the agreement?
Let's may have annexure number 2, which starts from 73 page 2.
With PWD.
Lordship, Karve Anglong division. It's under council law.
You are saying the chief engineer's office PWD is under
Additional
Karbi
chief
Anglong?
engineer, PWD, RNB, Lordship, under the council.
Oh. Okay, where we are recording your prayer for
Right.
implement of the Karbi Anglong Autonomous
Well,
Council.
we shall do the needful.
Heard council for the parties. An application on the 11/6 of the Act of 1996. Pursuant to the agreement executed by and between the petitioner, work was allotted to the petitioner. Was it completed or terminated?
Neither terminated nor completed, my lords. It was left in limbo in between.
The
No
work-
payments.
Work was not progressed with, and no order, no payments were received by the petitioner. Nevertheless,
But let's just one correction. Let's the first RA bill was paid partially. Apart from that, there were four in total RA bills. None of them were paid completely.
petitioner, according to the petitioner, executed the work, but apart from a partial payment of the running account bill, first running account bill,
Absolutely.
which was partially paid, rest of the bills were not paid. Left with no option, the petitioner that addressed the notice invoking the arbitration clause. Where is the notice again?
At page number 267 minutes. Annexure 14.
According, since no response is received from the respondents, the application has been filed for appointment of an arbitrator. There are Mr. B. Chaudhary, learned counsel appearing for the PWD submits that so far as Karbi Anglong is concerned, there is a separate standing counsel. As the additional chief engineer's office, road and bridges,
Yes.
RNB is under the council. If that be so, then the standing council Karbi Anglong will be furnished a copy along with a copy of this order. Let notice issue, returnable 4 weeks. The respondents may file their objections, if any. Matter be listed after 4 weeks.
Grateful, my lords. Grateful.
May I please, your lordship. Lordship, contemplation against the lordship order dated lordship 23/7/2005. Lordship, relevant portion lordship, page 18 lordship.
Heard council for parties issue notice, returnable 4 weeks. Steps on the respondents by speed post.
Lordship.
Released after the. Yes.
In this case, they will file a affidavit.
Huh?
They will file a affidavit. There being some scores for the accused.
Received affidavit today itself.
Mr. D. Chaudhary for the petitioner, Mr. D. Chetri appearing for respondent number one submits that he has filed his affidavit. Who is the respondent? One is the
It's a bar
council.
State Bank.
Filed the affidavit. Course of the day. Who's for Gauhati University? Yes. Why the certificate is not issued? Why who will issue the final? Huh? Who appears for the college?
appear for law for law from
Here's the response number 5.
Mr. So-and-so appears for respondent 2 and 3. Considering the issues raised, let notice issue. Another 3 weeks. So the respective counsel represents respondent 1, 2, and 3 notices of vote. However, extra copies be furnished within a period of 3 working days. Steps on respondent 4 by speed post within 1 week. Would you like to take Dusty?
Yes.
Service by way of Dusty is also permitted, provided you raise to your court and an affidavit of compliance thereafter in fact.
Okay.
Yes, respondents, what about the funds?
We have received the instruction.
Tell us, what is it? What is the name of your college?
CK College Chakla.
You bring it on record. Let them file your amount is not released, they admit.
Hello?
The amount, they admit that there was a decision to release the fund. Subsequently, there was some new decision taken where several other projects were there, where the name of your college was omitted. But the fund was not released, nor transferred, nor carried forward. So maybe it has gone back, we don't know. Let them bring it on record.
But the other institution that has said till our matter is disposed of, they may not release fund in favor of that school.
That we can't say because
That is, I am saying about
your development of your college is one thing, but because your college is not developed, some other college should not be developed.
no. Our that is also not our parent is only that our college was granted the fund. So
No, we understand
and-
that. We are only trying to tell you what is there in the instructions. Therefore, we have asked the respondents to bring it on record by way of an affidavit, so that you get to know what is there. So we'll have to issue notice here. Heard counsel for parties issue notice. Name is K. Fukon, appears for respondent number 1, 2. Therefore, no formal notices need be issued on respondent 1 and 2. Steps on respondent 3 and 4 by speed post. Within 1 week from today, service by way of Dusty is also permitted, subject to the same thing routed from the registry of the court. And then if Dusty's service by way of Dusty is affected, then an affidavit of compliance is to be filed. MSK Fukon appears for respondent number 2.
Yes.
Mr. S. Mia for 1. Correction. The respondents may file their affidavit within 2 weeks.
that verification.
9th of September.
Oh.
Okay.
Petitioner is agreed by the show cause notice. At page number 25.
You reply to show cause.
I have replied, my lord. In the meantime, my lord,
Ah.
some development has been taken place. My salary was, my lord, by this show cause notice, stop, thereafter, my lord, release. Now, my lord, they have not issued my lord formal order, like the at page number 32. I want to disorder by the district committee. Page number-
32.
Yes, my lord. In
What
my lord,
order?
other candidate, my lord, they have, my lord, issued the formal order. Now, in respect of, my lord, these two petitioner, my lord, they have not issued, my lord, which will, my lord, hamper in my service legal action.
That-
So
You get
I will-
instructions, respondents get instructions.
I only.
Get instructions, who will get instructions, who initiated it?
District commissioner is deputy commissioner. District commissioner.
District Commissioner.
Sorry.
District Commissioner, can you get instructions here? Third Council for Parties. The petitioner is agreed that pursuant to the show cause notice issued and the reply file, no formal order has been issued. Respect of the allegations leveled against the petitioner. Similar proceedings were initiated against other similarly situated persons. However, in response to the reply issued, formal order as reflected in Annexure A was issued. However, insofar as the petition is concerned, no such order is issued. Under such circumstances, at this stage, we permit the government advocate to obtain required instructions without at present issuing notice. Matter be listed after 1 week, after 2 weeks. However, extra copies be furnished within a period of 1 week from today. List on second.
Second September.
26th. 28th. 28th.
Item number 9, my lord, similar.
Item 9 similar.
Deeply obliged.
Lordship, my lord, this matter relates to non-payment of arrears salary of 50% for suspension period from 2/7.
Yes, Mr. Bora get instructions. Remand to the petitioner is non-release of area salary and 50% of the subsistence allowance, which the petitioner was required to be paid during the period he was undergoing suspension. Considering the limited prayer, what this court permits, Mr. P.K. Bora, standing counsel, education, elementary, appearing for respondent number 1, 3, 4, 5, 6, 7.
My lord, block limit, CRCC, my lord, actually SSML, I can.
7. Rules for finance.
Fine.
Mr. H. Olia appears for respondent number 2 and 8. The respondents, particularly the education, standing counsel education, will obtain required instruction. The list again on 28th. Extra copies be furnished within 2 working days.
Apply.
May I opinion? The speaking order is page 47. Similar cases will get already issued notice. This one from this honorable court.
What is your grievance? Tell us there.
Grievance Miller, petitioners, the case was considered by the DLC Miller.
Completion of appointment.
Yes, Miller. Thereafter, state during the pendency of the consideration.
When did your father expire?
Expired Miller. Expired Miller. 31/7/2015.
2015.
Yes, ma'am. A similar situated cases is already issued notice me. Yes.
2007.
Yes.
And there is a woman,
PS
woman,
66.
your lordship, office memorandum is.
Why notice is to be issued if similar cases are there? Give the number, will connect it.
Yes, PS 66.
66.
Lordship, Lord. Similar cases are common.
Third, counsel for parties issue notice returnable 4 weeks. MSP Das for the education,
Secondary.
secondary education. Anyone else?
There,
MSPA
Your Lordship.
1 appears for respondent number 3, 4. 2, 3, 4. 3, 4, and 5.
I'm appearing for respondent.
MS Das for 1. It is submitted that similar petition is pending before the court. That this petition be listed along with WPC 307 of 26. Is this the only writ petition?
Other cases also filed it before this court and.
You don't have the numbers.
I'm giving number.
All right, give the numbers. Release this matter together after the returnable date. Respondents will endeavor to obtain the instructions and place it into the court. Yes.
Deeply obliged.
May I please, Your Lordship? Lordship, the petitioner's candidature has been rejected by non-complying with the Honorable Division Bench order, my lord. The impugned order are at page 40. It's identical impugned orders, my lord. But there, basically, they have said that they have verified from the records database, but they couldn't found it for the year 2016 and 17. But the NIOS, that is the National School, Open School, my lord, is the main authority who have all these documents, my lord. Who have
Let
all
us
these.
issue notice first. Third, we'll issue notice for
My lord.
Mr. D. M. Dekkal and account. MS S. Surya, hearing for respondent number 1, 2, 3,
1, 2, 3.
1, 2, and 3. That notice issued. Returnable 4 weeks since respondent 1, 2, and 3 are represented. No formal notice may be issued. However, extra copies be furnished within a period of 1 week from today. Steps on respondent 4 and 5 by speed post.
My lord, 4 and 5 also have appeared.
Okay. Mr. Sheikh T. Sheikh appears for respondent 4. MS R.B. Bora for respondent 5. Since the respondents are represented, no formal notice need be issued. Extra copies be furnished within 1 week. Respondents may file their objections affidavit in the meantime.
Much obliged.
Yes.
Timing loss. Ego is depending is coming loss.
Huh?
Ego is depending is.
The fresh motion, tell us what is it.
So, my lord, we are challenging an inquiry report, my lord. Basing on this honorable court, my lord, the University Grants Commission was directed to, my lord, conduct an inquiry as regards my PhD qualification. My lord, though the report had been prepared long back, but my lord, it had been come to our knowledge only by of an affidavit in a connected writ petition, which is also listed today, my lord. Item number 38, my lord. So, my lord, in this petition, the ground of challenge is that the inquiry which had been conducted.
Well, we'll call up along with item 38.
Yes, yes, my lord.
Same
Yes.
matter,
My
similar
lord,
matter.
my lord,
By
connected.
the same petition.
Same petition.
Right.
My lord.
Call up along with item 38.
My lord. Obliged.
Last occasion, my lord, your lordship, court order dated 12/6/2005.
Yes.
Last occasion, by order dated 12/6/2026, my lord.
Yes.
Last order, my lord. Married, my lord. At this stage, so and so, Mr. T. should SM to 60 learned counsel for the S1 or instruction submit that his client may be granted a last chance for 4 weeks to comply with the order, though with reluctance as a last chance adjournment is granted, this so and so. If by the said date order is not complied with, this court may be direct the personal appearance of the respondents and may pass an appropriate order against their officials. So actually, my lord, order annexed to page 20, the content, my lord, your lordship order passed on 27/11/2020. Thereafter, review was filed, that was also dismissed. They filed writ appeal, that was also dismissed, my lord. They did not comply with till today, my lord. And my lord, honorable court so many times that given the time, my lord.
Here with the preferred and SLB member.
You have preferred in
SLB member.
preferring and getting an order for SLP is different. When did you file it?
On 8/8.
8/8. SLP is likely to be listed when? This year or next year?
We're trying to.
We'll give you 2 weeks. Further 2 weeks. You give us place. We'll give you 3 weeks. You tell us what is the status of the SLP. 3 weeks further time to place before us the status of the SLP stated in the file. Otherwise, we'll proceed with contempt. Mr. N. Bora from petitioner, Mr. P.K. Bora. What is respondent? So, the respondent submit that against the appeal, which was preferred against the order passed by the tribunal bench, by the coordinate bench. The appeal is to dismissed and an SLP has been preferred. The status of the SLP is not known to him. He therefore prays for further time. Apprise the court on the status of the SLP file. Considering the submissions made, let this matter be listed immediately after 3 weeks on 9th of September. The respondents will apprise the court as to the status of any orders that may be passed in the SLP filed by the respondent. Yes.
Fifteen also, your lordship may see the last order, my lord, 12/6/2026. Where it is clearly reveals, my lord, the circumstances. Because each and every time, my lord, they're taking time, giving this, that, my lord. In fact, relying on the honorable apex court. order,
Yes.
it says it is a criminal contempt.
What was the direction of the court?
Direction, my lord, your lordship will find it. Please 14, my lord, of the contempt. To appoint, my lord. Please 14 is the direction. Your lordship may see the first paragraph, my lord.
So there was a direction to consider issuance of appointment.
Appointments. Because, my lord,
So apparently this has been considered and your case was found to be devoid of merit.
yes, that is the ground, my lord, they are taken. But the consideration of this writ petition was the sole, that aspect only, my lord. That why it is rejected. That means they have, my lord, defied the judgment of this noble. Direction of this. If your lordship may kindly see the order submitted by the my learned.
No, first take us to the order of the court.
Order of the court, my lord. If your lordship, page 14 from page, if your lordship may read page from page 13 onwards, my lord. What was the case there? The petitioners belong to STP, second paragraph, my lord. category and response advertisement that is to applied for post of Assamese language teacher and assistant teacher in lower primary, upper primary school. They were allowed to appear in the recruitment process and they were found to be qualified. However, no appointment order was issued to them on the ground that they did not possess the requisite qualification before they attaining the age of 40 years as mentioned in paragraph 5 of the advertisement. That was the ground for which aggrieved by the non-issuance of the appointment order stated, as stated, they are before the Honorable Court, praying for issuance of appointment writ or order of direction directing the respondent to issue the appointment order. It is submitted by the learned counsel for the petitioners that in similar cases, after Honorable Minister of Education had directed that case of such persons may be compared to the government, Assam had issued a corrigendum on 2021. This was issued later on, after the advertisement issued, this corrigendum. Assam Gazette removing the equivalent requirement of passing the required qualification before attaining the age of 40 years. Therefore, appointment orders of the petitioners may be issued if they are found to be qualified otherwise. So that was the case, and some cases, those cases were considered. And then my learned friend was there, my Mr. Kaushik, learned standing counsel, education department, appearing for the respondent 1, 2, 3, clearly submits that since cases of similarly situated persons have been considered, a similar direction may be issued so that respondent may consider the issuance of appointment order to the petitioner. In that case, they are found to be qualified otherwise. So that condition that they attain the age of 40 years, that was the issue, man. They completed their education. Then this direction was that taking into consideration the facts and circumstances of the case and the submissions of the both the learned counsels and the order passed in similar cases, the writ petition is disposed of with the direction that the respondent should consider issuance of appointment orders to the petitioner in case they are found to be qualified otherwise within a period of 2 months from the date of receipt of the copy of this. So there was a clear direction from the Honorable Court to issue appointment order.
Now,
Otherwise, if
what
otherwise qualified.
What direction was issued by the other courts, which references are found in the order? Some writ petition orders passed.
Some writ petitions order passed, my lord. My lord, voted if your lordship may, what my submission will be, because the issue before your lordship was, so if your lordship may kindly call for my writ petition. Along, because my lord, what my submission is, the sole contention was that the corrigendum, whether after the corrigendum can we be appointed or not.
Is the corrigendum here?
The corrigendum is not there. It is their submission, my lord. They have said that it has been removed. And it is the consenting order, my lord. If your lordship may kindly see, it's a consenting order.
No, there is no quarrel that
Corrigendum
your case is to be considered found to be otherwise qualified.
Otherwise, so there, my lord, the contention of the writ petition was that the 40 years bar may not be, my lord, may not be a bar for the petitioners to be appointed. That issue has been dealt with by the Honorable Court. That's why it is. That's why this Honorable Court said.
That issue has been dealt with in a sense that it has referred or relied upon the orders passed.
Passed. Well,
what are the orders passed?
My lord, day before yesterday, probably there was another case, my lord, I submitted before this Honorable Court. Similar order was passed in that case also. Where, my lord, there is another court of the coordinate bench of this Honorable Court say, because my lord, their point is now they are raising.
Why don't you place these orders which are relied upon by the writ court?
I can bring it.
Bring it on record. Let us see what was decided there.
Yes. My lord, if they can, this is the order. If they can bring this into the by way of an affidavit, then it will be better. Otherwise, my lord,
bring it by way of an affidavit.
Yes, it will be better. Let them bring this documents into the affidavit by way of affidavit. Then I can file reply of that. Otherwise, my lord, it will be
heard. Counsel for parties, the respondents are placed before the court order dated 11/8/2026, which the respondents submit, and by which the respondents submit, and it had considered cases of the writ petitioner, and upon examining the same, as is detailed in the order, the same was found to be devoid of merit. Therefore, the claim of the petitioner could not be considered. The respondents seek gravely of the court to bring this on affidavit. Prayer made is allowed, released after 1 week.
This case, there's a, it has been pending.
Still pending.
Yes.
Any order?
It is,
Yesterday it was
it is
listed,
fixed
but
on
it took time.
5/10/2026. The matter.
But is there any stay order? It is submitted on the bar that the next date in the writ appeal. Writ appeal, what is the writ appeal number?
270/2024.
Being WA 270/24 is listed again on
It is on 5/8/2026. 5/10.
5/10/2026. Matter therefore stands deferred to be listed after in the month of November.
This case also, my lord, down about for last occasion directed that if the order is not complied with by today, personal appearance or appropriate order may be passed.
Here also
Already-
filed an SLP.
My lord, for last 8 months, they are taking the same grounds, my lord,
Well, we have filed, we have the diary number.
that how the client
All right, we'll give you 2 weeks to give us a status.
sort that may be weak, my lord.
It is submitted by the council to the respondent that an SLB has been prepared against the judgment and order, of the division bench, whereby the order passed by the coordinate bench was upheld.
Yes,
The details of which have not been placed before the court. Details of the SLP are not available in the council. He is permitted 2 weeks' time to apprise the court of the status of the SLP file. Mr. N. Sharma appears for the petitioner.
there is urgency, my lord. Petitioner is a retired teacher without.
28th,
28th August. One observation may be made, my lord. As far as
26th August.
one observation, if there is no stay order, the order may.
No, it will be 28th only. 28th.
One observation, my lord.
That observation is there already. It's there. Proceed. You remind the court that an observation is there in this order.
Client will, my lord, they are satisfied, my lord, on us, my lord, client. On various
You
occasions,
tell
they are-
them you tell them that their dissatisfaction should
Yes.
be directed against the court.
on
not
various
against-
occasions, on various same grounds have been taken for last year.
You tell them the judge is hopeless, he doesn't listen to us. What to do? You can only submit, doesn't listen. Yes, next matter.
Yes, madam, on last occasion, the finance department was asked to produce the instruction, madam.
Lordship, I have received the instruction, Lordship, here. As per the director of pension, they have reissued another PPO in the name of both the wives, Lordship. Lordship, I will seek 1 week's accommodation because 2 people are not drawing. One is from Dorong Treasury and I have the instruction from Udalguri Treasury Officer. So
Yep.
that, yes, 1 week time may be granted, Lordship.
Second wife. First wife.
First have died, madam. I am the second wife.
Yes, yes, their name, the son.
Your file. File. Don't read from the court. Mr. A. Chaliha, Standing Counsel Finance, submits that fresh PPOs have been issued. However, in view of the pension being claimed by the two legal heirs, two wives, widows of the late government servant, and from different treasuries, it prays for a week's time to complete an instruction and place it before the court. Mr. Mia, here for the writ petition.
The date may be fixed.
But after independence.
You wanted 1 week.
Yes, Lordship. Today's yes, Lordship, yes. After 20th.
21st, 24th.
24th.
Deeply applied.
Based on 24 August.
It's non-compliance of order dated 6/9/24. And it is the last order.
Complied.
Past and present.
Where is the direction of the court?
It's number
Page number
10. The page number 20.
Litigant-in-person, there are 23, 24.
So paragraph 3, the direction Elementary Education Department Assam would now initiate conclude the process requesting the issuance of necessary orders to other provincialization of service of S1 within 2 months.
What is the order passed here?
Here, my lord, Commissioner Zahiruddin, not my lord, opinion to appoint, my lord, because my lord, kindly see the remark column. First page, my lord.
They are appointed or not appointed?
No.
Huh?
My lord, he is not fit to appoint, my lord.
He is not appointed. But you bring it on record.
My lord, I'll
Bring it on record. Mr.
RCL.
R.C. Alam appears for the petitioner, Mr. P.A. Bora appears for the respondent. He submits that by 18/7/26, the orders have been passed by the Director of Elementary Education. And upon examination of the matter in its entirety, the petitioner was not found to be eligible for being appointed. A. Jalaluddin.
Well, he is the respondent in the main petition.
Huh?
He was the respondent in the main petition.
Let these orders be brought on record by way of an affidavit within 1 week from today.
Well, let
Yeah.
Hello, the order is not compliant. Because relates to the family pension.
We have prepared an appeal in the last order recorded, and but appeal is yet to be listed. There is some defect cleared it, listed soon.
The order is not.
It is submitted that against the judgment and against the order. Where is the order of the court?
Page 14.
Order dated so and so.
30/10/2024.
30/10/2024 passed in WPC 1672 of 2017 and writ appeal has been preferred. It is submitted. The matter is likely to be listed within this week. Under the in view of the submissions made by the respondent counsel, let this matter be listed again on 21st, by which date the respondents will apprise the court about the status of the writ appeal stated to have been filed against the said judgment and order dated so and so. In the event such instructions are not placed before the court, it is left open to the court to pass consequential orders.
Can it be on 24th?
24th.
Problem.
Yes.
I need some time.
Mr. Mazumdar for the petitioner, Mr. P.K. Bora has entered appearance on behalf of the respondents. He prays for some time to complete instructions and file necessary affidavit. If so advised, he prays for 2 weeks' time. No objection?
No objection.
Prayer made is not objected to. Raise this matter again after 2 weeks on 28th August.
But
Lordship, may I pray that the matter may be taken up after some time.
Why?
Mr. P. Bodler is on legs for another court.
Why is it for orders?
Lordship, I have no instruction.
Otherwise, in item number 25, we have already filed our affidavit.
You have filed your affidavit.
Yes.
That affidavit will cover both the cases. No, 24 and 25.
Yes, 24 and 25, and we have filed our affidavit in 25, and it was filed by D. Musari.
Huh?
D. Musari has filed the affidavit, my lord. And yesterday only it is filed now.
May I submit one thing, Lordship? We have not served the, we have been not served the.
You'll get it, you have filed yesterday, recorded. Mr. P. Bodler for the petitioner, Mr. U. Sharma for the respondent, submitted that an affidavit has been filed in WPC 5810 of 25 yesterday.
Yesterday.
So without serving the petitioner, Lordship, how can they file the affidavit?
The counsel for the petitioner on the other end submits that no copy have been served on the petitioner. Respondents. In the event the respondents have filed their affidavit, copies thereof must be served on the on all the parties before the court. Let this matter therefore be listed on 24th of August, by which date the respondent will apprise the court on the status of the affidavits filed.
So with regard to 24.
24.
Lordship.
Both are connected, isn't it?
Lordship, connected matter, Lordship. They have filed affidavit
In
on
25.
In petition number 5810 of the 2025.
In 25.
Lordship, but not on not in 24.
So whether one affidavit will suffice or you want two affidavits?
In this matter, I have to go through it because it was filed by the
respondents will also apprise the court whether they intend to file any affidavit in WPC 3564 of 25.
Hoping maybe start.
We have already indicated,
Yes.
24th. 24th August.
Lordship. Oblige, your Lordship.
My lord, last occasion also that your lordship has asked them to take the extraction with regard to the compliance of the order.
They have appeared today, let them obtain their instructions. The respondents, how many respondents? One. Two. You are appearing on both for both.
They have filed for respondent number 1.
FSS Sudhi appears for respondent number 1. She submits that she would like to obtain instructions in the matter. Release this matter again on 26th of August. Mr. P. Chakraborty appears for the respondent, for the petition. P. Profession. Sorry.
This case, my lord, last occasion they have taken time to file affidavit.
Yes, any affidavit?
The instruction is awaited, Lordship.
Huh?
Instruction is awaited, Lordship.
Instruction is awaited. Who is the respondent for?
Respondent for as private.
Private respondent.
Is that one the principal petitioner has not been allowed to hold the financial charge of the school as a principal?
Mr. B. Purkashta appears for the petitioner. MS N.M. Sharma appears for the secondary education. Stop. By laws in my order dated 23/3/26, service on respondent number 4 has been deemed to be completed. However, none represents the respondent number 4. Matter therefore will proceed ex parte against respondent number 4. Relist this matter again after 2 weeks on 28th of August.
60 hours. Yes. Then. Okay. Mute. May it please your lordship. My lord, your lordship may kindly see order dated 15/5/26 and 22/7/26.
Yes.
Director of Higher Education, they are supposed to take action on the basis of the report submitted by the authority as regard caste certificate of the Is anybody there? In court?
What exactly is your claim in the petition?
Well, this application, we have challenged the appointment of respondent number 9, respondent number 8. Your lordship may kindly see page 26 of the petition. After advertisement, this list was prepared. Page 26 of the read petition. That's a selection list, my lord. Serial number 102.
They have issued a show cause on the respondent number 8
Yes, my lord.
on 11/8, which is yesterday. What sometime? You want
Then
some
let
time
it be up
to complete your instructions, or you want some time so that he can come to court and file challenges? Whose behalf are you making the prayer?
No.
But insofar as the
Then-
petitioner, what steps are you taking? So far as the claims of the petitioner, what steps are you taking? Mere issuance of a show cause will not ameliorate the grievance of the writ petitioner. The writ petitioner is a STP.
STP, my lord. And the respondent number 8, my lord, he has got a false certificate showing himself as STP. Now the committee has found that he is not STP. That report, your lordship will get it at page 54. 54.
All right, a show cause is issued.
Even without a show cause, it is removed directly.
Well, they are already here. They are represented in this case, my lord.
Who represents the respondent 8?
No, none appears nowadays. Nobody appears, my lord. Earlier, the Wakalatnama has been filed.
Was there any leave granted to the respondents to issue show cause? Was there a
My lord,
direction?
no direction, my lord. There was a, the
So why
last
they
direction was
unilaterally proceeded in the matter? When the matter, the court is in session of the matter?
my lord, your lordship will kindly see the last order dated 22/7/26.
Respondent is working under whom?
Respondent
which
is
office?
working under a college, man. Respondent number 5.
Respondent number 8 is working under which college?
Respondent number 5, principal.
Respondent 5.
Pandit
Who's appearing
Dind-
for respondent 5? Who appears for respondent 5?
Education Council, my lord. Earlier, the action has to be taken by the Director Higher Education only, man. Because his appointment is page 27, his appointment order. Appointment order is at page 27 by Director Higher Education.
Who's for respondent 5?
Education. Education.
Well, page 27, appointment order has been issued by Director Higher Education. And respondent number 5 must be, my lord. Standing Council Higher Education.
Government college can appear. Principal.
All right, since you have issued notice, you take steps within how much time you have given him to respond?
10 days.
Well, otherwise, your lordship will take the matter for hearing, my lord. Admission hearing, because the authorities are
We'll
probably
take
not
it
understanding
for
the
admission
matter.
hearing in the month of September. Matter be listed on September 11th. Meanwhile, the respondents will apprise the court as to the steps taken by the respondents.
Admission hearing.
In respect of the respondent number 8, pursuant to the show cause notice dated 11/8/2026 issue. Let it be listed on 10th of September. For admission.
8.
10th.
Take it, I'll be here.
Yes.
Case my lord, we have filed one this case for modification of the interim order, my lord.
Which interim order?
Interim order, my lord, the first one is granted page 22. Order dated 17/7/2026. That is the order of status quo. What happened, my lord, during the pendency of this case, after granting of the status quo order, my lord,
No, you are filing modification by this IA.
yes,
Where is the order?
order
In
is-
the IA.
order at page number 20, my lord.
20.
Yes.
Yes.
Like to find that.
All right, heard counsel for the parties issue notice returnable 2 weeks. Since the opposite party petitioner is represented by Mr. Sharma and the state is represented by Ms. N. Fukan, appearing for the education department. This is the way the extra copies be furnished within a period of 1 week. Petitioner opposite party number 1 is permitted 2 weeks time to file legal objections, 10 days time to file objections. This is the matter after 2 weeks.
Urgency on our part, my lord, to take 2
weeks, 28.
Under order maybe.
We have not vacated it. But you file your objections in 10 days as directed, or we vacate it.
Definitely. Okay.
Objections filed?
Today, I think there is a affidavit filed.
The opposite parties have filed their objections today. Matter therefore be listed for admission on is there you are objecting to the prayer on 11th September.
My lord, in terms of my lord's order, the respondents, they filed their affidavit only yesterday, my lord. And their copy was served on us yesterday. I'm praying for some time to.
Mr. H. Buragoy, counsel for the petitioners, admits that the opposite party has filed their objections yesterday. Raised for a week's time. 1 week or 2 weeks?
2 weeks will be.
2 weeks time complete his instructions, release this matter again after 2 weeks. Mr.
P. Jha on behalf of
P.
P. Jha.
P. Jha appears on behalf of the respondent.
On behalf of DP Bora.
On behalf of
DP Bora.
DP Bora. Based on 7th September.
I'm highly objective.
Not supported on the directed.
We have the instruction. Let us file our affidavit.
Mr. P. Bora for the petitioner, Mr. P. Bora for the P. Bora respondent who submits the instructions have been received. We pray for 3 weeks to file the raise affidavit. The respondent, the petitioners are also permitted to file the rejoinder. Such an affidavit as may be filed by the respondent. Release the matter after 3 weeks. MS Sharma appears for Accountant General. MS Fukan for State. Respondent said.
Section 11. The respondent have filed their objection. The main contention is that after we had approached this honorable court for under section 11, the respondents have.
You're not filing your objections.
No, Your Lordship. The main contention for the respondent is that they had given us the names of 4.
Let us have it in September 1st week. 3rd September.
Good.
Release this matter on 3rd September.
Repeat.
The objection is not yet filed, madam. Mr. K. Gogoi had appeared.
How much time? Mr. K. Gogoi, MS NN Sharma, appearing on behalf of Mr. K. Gogoi.
Gogoi is here already.
But she can still appear on his behalf. Praise for 3 weeks. Time to complete instructions and file objections. Mr. B. Pathak appears for the writ petition. Released again after 3 weeks.
Otherwise, this thing is
7th September.
Obliged, madam.
Yes. Yes.
Yeah, in this writ petition itself on last occasion, last Friday, and affidavit compiling the inquiry report, which was directed by this court, has been filed. That very inquiry report is under challenge, Lordship. And supplementary I can get this.
So whatever will be the outcome will govern this.
So, Lordship, the inquiry report was of the year 2023.
Whatever it may
there was a very direction of this honorable court in that case, subsequent to which they have conducted the inquiry to provide a copy of the inquiry report to us, but they have kept it confined.
You are challenging it now.
Yes, Lordship.
By a fresh writ petition.
Yes, Lordship. And there are lacunas in the inquiry report, Lordship. There is no whisper of
whatever it may be. We are not dealing with the inquiry report now. We are dealing with this 2014 matter.
Lordship, in the 2014 matter, there was the honorable Higher Education Department submitted an affidavit, Lordship, regarding the genuineness of the PhD of the petitioner, Lordship,
right,
which was under observation of this honorable court. So, with regard to that affidavit, we have challenged the report, Lordship.
Where is that impugned order in this writ petition? What impugned order you are telling? The 2014 matter? What impugned order? Is that page number 109?
Yes, Lordship.
Your recommendation was that of a assistant professor.
Yes, Lordship. This very order
No.
is challenging. This repetition.
Because your order for the principal came after the Act of 2011.
Their contention is there, Lordship. Department's contention is there. Lordship. But
Not contention, it's a matter on the facts. There is no dispute on facts.
yes,
Your
Lordship,
your appointment was when? As a principal, where the governing body? Governing body 4/6/2011. 4/6/2011 is the selection.
yes, Lordship.
And 1/1/2011 is the act.
Yes.
So on the day when the act came, you are not a principal. You are an assistant professor.
Yes, Lordship.
Therefore, your assistant professorship has been accepted.
But Lordship, our appointment was with effect from 31st December 2010.
That is not that is what they have not inclined to do so.
May I be permitted?
Yes.
Milord, the new petition, Milord, which we have preferred, is challenging the inquiry report regarding my PhD qualification. Now, Milord, in the main writ petition, which was, Milord, pending from since 2014, is a challenge to the impugned speaking order. My Lordship already has gone through, and wherein, Milord, this section 2 subclause H has been invoked and making me, Milord, not eligible to be provincialized as a principal.
Yes.
Now, Milord, as I have already, Milord, demonstrated before my Lordships, that, Milord, this section 2H is, Milord, interpreted in such a manner by the department. Similarly situated person has been given and extended the benefit. Like
That
me.
that will fall under negative equality.
No, Milord. It is the, Milord, with all respect to my
You're referring to which provision of the act?
provision of, Milord, this section 2 clause H of the, Milord, 2H of the, Milord, Act of 2013. My Lord, may be pleased to find
2013 or
no, Milord, because this case was this speaking order was issued, Milord, basing on this 2013 Act, Milord.
13 or 11?
Sorry, 11 Act, Milord.
11.
Assam Hansar Educational Institution Provincialization of Services Act 2011, Milord.
11.
It is available at page 647 and the relevant part is at page 649.
Yes.
Section 2H.
Yes.
Employees means and includes all serving employees, both teaching and non-teaching, of Bansar Educational Institution who have been appointed by the concerned Bansar Educational Institution before the first day of January 2011 and whose services are being or would be provincialized under this Act. So, my lord, who have been appointed means, my lord, this has been interpreted by the department, not, my lord, with a negative equality. The interpretation had been, my lord, used in such a manner. The past service of an employee who had been working, my lord, in that particular college is not amounting, my lord, if this is going to be applied on the date of the new appointment, then the past service is going to be wiped out.
How?
Because, my lord,
How will it be wiped out?
because, my lord, these persons, my lord,
The
who has
question
been,
is, on the day when the act is enacted,
my lord,
given effect to,
my lord,
are you there employed or not? Number one.
my lord.
If yes, then in what capacity? So on 1st January 2011, you are an assistant professor. Your case may have been considered for principal, but effectively you are holding charge, or your cadre is assistant professor. So
Yes.
you'll be provincialized as assistant professor. Your claim as to whether you should have been given or accepted, not accepted, the subsequent claim.
No, my lord,
Had your selection as a principal would have been on 31st of December 2010, you would have been provincialized as a principal.
Lord, on a plain reading, my lord, it appears to be like that. But, my lord, when we go through the records, the entire provincialization exercise which had been carried out in the entire state, my lord, the benefit of this section 2H had been extended to those persons also, my lord, who were.
That would be contrary to the provision of the Act.
No,
The
Lord, it
statute.
is, my lord, with all respect, with my limited understanding, my lord, as this have been appointed, in what category of post, it has not been said in the 2H of the clause, my lord. That's why, my lord, they have been appointed the.
Mr. Counsel, you simply
My
read
lord.
the provision. It says on 1st of January 2011.
That is correct, my lord.
What post were you
No,
holding?
no, first of
What
January.
post were you holding on
No, I
1st?
am holding the assistant professor
Then
post.
your provincial license assistant professor, end of the story.
No, no, my lord, I am, but my selection and appointment as a principal, my lord.
Your selection and appointment thereafter, your
Then
it
it
is
will,
available
then,
for you to
then, my
challenge
lord,
that
it will, then it will.
subsequent to your being provincialized as assistant professor,
Well.
after you are promoted or appointed as a principal, now you'll be provincialized as a principal. It's open to you. But if definition under 2H
Well.
is to be seen very clear, there is no ambiguity in this provision. There is no scope to interpret it. Statute is very clear.
No, my lord, that's why, my lord, we have bring the relevant records, my lord, in my petition, my lord, of which my lordship has already perused in many colleges, my lord. Those persons who were working as an assistant professor before the cut-off date, they had been promoted or, my lord, upgraded in the post of principal after the cut-off date. But their date of initial joining and appointment in the provincialization order had been shown the date of the assistant professors, my lord, not the date of the principal, my lord. That had been done. If my lord may be pleased to take a few of such, my lord, the notification of the records which I have relied, my lord.
Now, in the fresh writ petition, you are challenging the inquiry report.
My lord, the inquiry which has been conducted, my lord, behind my back, not a letter had been asked for me by the inquiry officer.
All right, here we'll issue notice then.
My lord, my lord.
Heard Mr. A.R. Bhuiya, senior advocate, assisted by N.Z. Chaudhary, appearing for the petitioner, and Mr. who's appearing, K. Gogoi, appears and accepts notice on behalf of the Higher Education Department. And who's for M.S. Borpuzari for UGC? However, therefore, notices on in respect of respondents 1, 2, 3 stands waived. However, extra copies be furnished within 1 week. Steps on respondent 4, 5, 6 by speed post within 1 week from today. Matter be listed after the returnable date. Now, insofar as this matter is concerned, we have heard you. We'll pass orders.
My lord, as the matter is connected, my lord, on the returnable.
How is it connected?
Because, my lord, they have said that I am not eligible and qualified. My PhD degree is fake and false.
That is a challenge made to your non-selection as a principal.
No, my lord,
Or non-provincialization as a principal post 1/1/2011.
Exactly, my lord. Now, here is a case, my lord. Yes, my lord. Here is a case wherein we are challenging the speaking order, issue of the interpretation, as well as the, my lord, subsequent action of the government regarding giving
Prima facie, we don't find anything wrong with the speaking.
No, my lord, if my lord may allows me.
If you interpret
section 2H, my lord. No, my lord,
where the statute is clear,
my lord.
no further, no interpretation is called for by taking recourse to some other external means. Statute is clear.
No, my lord,
You are on the day 1st of January, if you are employed in the venture educational institution,
my lord,
you are provincialized.
my lord, just for my satisfaction, my lord, may I read again, my lord? This
Yeah,
2H, my lord. Employee means and includes all serving employees, both teaching and non-teaching of venture educational institutions who have been appointed by the concerned venture educational institution before the first day of January 2011 and whose services are being or would be provincialized under this act. Now, my lord may kindly appreciate that this sentence, venture educational institution who have been appointed by the concerned venture educational institution before the first day of January 2011. Admittedly, my lord, and I will not submit an unfair submission, my lord, I was appointed as an assistant professor on 1995, my lord, as an assistant professor in the Department of History. Now, my lord, it says that 2011. Now, my lord, once my selection and promotion, my lord, has been on 4/6/2011 as a, my lord, employee as in the post of principal. So, my lord, it is obviously beyond the cut-off date. That I cannot deny. But my lord, it has not been said who have been appointed by the concerned venture educational institution in what post or in what category. It has not been disclosed here. Before, my lord. That is correct, my lord. But employee, my lord, if we read the word employee, my lord, it will have an access with the original appointment, my lord. It will have an access with the original appointment.
Have an access. It is not a question of counting your services.
That has been done, my lord.
No, it's not.
My
You are not claiming service benefits.
No, I am not claiming service benefit, but my selection and appointment
Your
as a
selection
principal.
and appointment is post 1/1/2011.
But my lord, the
So
direction.
on 1/1/2011, you are an assistant professor.
That is admitted, my lord. That what is on
Had
record,
it
my
been a
lord.
case
My
that you are not appointed or not selected as a, or you are selected as a principal, but your services rendered prior to 1/1/11 as an assistant professor has not been counted. You certainly have a case. Here is a case where on 1/1/11 you were an assistant professor.
Then, my lord, I will be a victim of discrimination. My lord.
Discrimination cannot be applied in negative equality.
No, my lord. Negative equality they have not done. All the employees, my lord, all similarly
If there is a policy decision taken
My lord.
that this 1/1/2011 benefit will be extended for 6 months or 1 year,
My lord.
then yes, suddenly you are entitled. But in the plain reading of the provisions of the Act of 2H.
That is correct, my lord. That is correct. But my lord, the department, while doing the exercises carried out, all the employees, my lord, who were appointed prior to my lord, 2011, they have been given the benefit of their original date of appointment, except this Lukman Ali. Except this Lukman Ali, they have done this, my lord.
You can put it in ICU for as long as you want, but the end result is going to be the same.
No, my lord, I am not on that, my lord. As my lordship has considered my plea, my lord, and whatever order my lordship is going to, we have to be obliged, my lord.
No, you can. You are entitled to convince us.
My lord.
To the
Then,
contrary.
my lord, one opportunity can I be free, my lord, on the next, after 15th, my lord.
After 15th.
My lord.
Better. After 15th, choose a better day.
My lord. Any date as per
Any day. Huh?
Some more auspicious day.
He wants to pump in more oxygen.
My lord.
Tell us anything.
My lord, can it be on 22nd of August? No, I do not have any choice, my lord. It is the-
September.
My lord.
September. 3rd of or 8th of September.
My lord.
8th September.
My lord. Obliged. Declare.
Better be listed again on 8th of September.
This related challenge to the inquiry report, it was on his petition that the court directed inquiry.
Rejoinder file.
There are in the meantime, there are some that are pending which are affected also.
But the matter as it stands now, my lord, they have already appointed after the Supreme Court's order. They have been appointing the identically situated persons, my lord. And that too after filing of the contempt application. Why they are trying to, my lord, they my lord, my reply to the rejoinder, my lord, we have annexed a copy.
These are music teachers.
Yes.
Music teacher.
So music teachers, Supreme Court has already
Yes. We have
They are-
dismissed.
That petition has one basic difference.
Ah.
That they have claimed the regulation, provincialization under 2011 Act. District Scrutiny Committee has recommended their name, but State Selection Committee has not done anything. And in the meantime, 2011 Act has been struck down by the Congress. That's why
That is the whole story, my lord. That is already decided.
All right, we'll fix it on 25th, 18th. 18th. The things are exchanged,
Not on
matter be
18th of
listed.
August, man.
Huh?
Not on 18th of August, man.
25th.
Yes.
Matter be listed on 25th for admission.
My lord, I'm sorry, my lord. Can we have between 25th or 18th, my lord, any other day?
20?
Yes, 20th. Thursday, 20th.
20. Yes.
the burden the service pension along with area pension, my lord. I was retired in my lord 31/7/2019. From 9/1/2020.
Yes, who's the respondent? Yes.
Find our respective matter. The petitioner service was never proceeded, madam.
Hmm?
Service of the petitioner was never proceeded.
Why was it not provincial?
File our
Affidavit filed. Rejoinder?
No, my lord, we have filed our reason.
Rejoinder, all right.
Ten-
We'll keep it for,
10/5/2020.
we'll keep it for hearing. The pleadings are exchanged, the matter be listed for admission hearing. When?
Next,
Next week. 18?
April.
Very pleasing lordship. Matter pertains to area pension benefits. Kindly here is the last order.
Yes.
One last topic on the one section was thoughtful that matter was pending before the Honorable His Excellency of Governor of Assam for recorded approval under Rule 205 and 206. That approval notice we have not received. So I am praying for another 4 weeks. In the meantime, we receive instruction.
4 weeks time is too long a time for somebody's pension. The respondents are permitted 2 weeks further time to complete their instructions, failing which the court will proceed to issue consequential orders. Release this matter after 2 weeks, 28th August. MS so-and-so for petitioner, Mr. P.P. Sharma for Dotto for the respondents.
Item 42, I am for the petitioner. Except the private respondent 8 and 9. None of the state respondents have filed their affidavit till now. The 23 matter otherwise. But except for the private respondent numbers 8 and 9, the state respondents have not filed their affidavit.
What are you claiming here?
Lordship, here we have based our entire petition on an inquiry report submitted by the Fee Regulatory Committee pertaining to the affairs of the school. That inquiry report, we have relied upon that the authorities have not taken any action on that. In the next item, item 44, my learned friend had assailed the validity of that inquiry.
Have you what any counsel to file their affidavit?
Lordship, I am for respondent number 8 and 9. We have filed that.
You have filed. Who is required to file?
Lordship, the state respondents have not filed as to what.
Who are the state respondents here?
I am for the secondary education department, and they have challenged their 8th degree of the respondent, and moreover some fake there are some fake my lord students so that and they have appointed as a principal under Moringatham Dev Singh Memorial Academy. And they have also claimed that the name has been falsely sent as Moringatham Dev Singh Memorial.
Why don't you bring it on record? File it, whatever instructions you have, bring it on record. So that the petitioners get an opportunity to rebut it if they want.
The only thing is that inquiry report was submitted by the
I have not received any instruction here, madam. So, madam, this 3 weeks may be granted so that I can.
3 weeks time.
An inquiry report is submitted. The inquiry report is under 7th minutes. Therefore, what the authorities have done upon the inquiry report, that is for the state to answer now.
The secondary education.
Yes, I am for the secondary education.
Secondary Education Council is permitted 2 weeks time to complete instructions and file their affidavit. Mr. D.S. Bhattacharya appears for respondents 7 and 8. 8 and 9. And the responses have been filed. Mr. P.P. Dr. for respondent 6. Have you filed your affidavit? Respondent 6. Represents the MSN Fukan appears for respondents 1 and 2.
Yes.
The
respondents 1, 2, and 3.
And 3 for
and 5.
I am appearing for the 3 and 5 man.
3 and 5. We'll complete their instructions and file affidavit within a period of 2 weeks, 3 weeks. Yes? MS so-and-so appears for item number respondent 4 in item 44.
Here for the petition, item number 40.
Ms. So-and-so appears for the petitioner. You're appearing, your name? D. Chakravarti appears for the.
5 region.
Let both these matters be listed immediately after 3 weeks. Give your names to the council, to the court master. I would like to relist on 10th September.
Much.
But here in this case, very short question involved, my lord. Your lordship will turn to page 63.
Yes.
So, my lord, your lordship by this order directed to place the case of the petitioner before the DLC, but the authority failed to do so. Then we can be good. They file affidavit in opposition, my lord.
What direction do you want from the court?
No, my lord, thing is this, my lord. Accordingly, the matter is again, page 66, my lord. Matter is again remanded back to the DLC, Sirang district, to reconsider the case of the petitioner in terms of clause 15 of the OM dated 1/6/2015 and commensurate to her education qualification. And thereafter,
Has it been done?
to its next immediate meeting.
Yes.
That is to be done.
Filed by the respondent number 3.
What does it say?
Director of Education. But here in this case, lordship direction was given to the respondent number 5.
DLC.
DLC lordship.
Yes. Who represents DLC? Is it placed before the DLC? The MSK Fukan appearing for the state will obtain instruction whether the petitioner's case, upon being remanded back by the order dated 21/7/2023, passed in WPC 3470/23, was placed before and reconsidered by the DLC. Let this instruction be placed before the court in 2 weeks. Mr. M. S. Sheikh appears for the petitioner. Mr. B.C. Musari appears for the PTC. Released after 2 weeks.
Date by
28th August.
The pleadings are complicated. They have filed, principal has filed affidavit, we filed in the reply. So
It is submitted that the pleadings are exchanged, the matter be attempted to be disposed of at the stage of admission, released on 17th of September.
Observation with respect to the maintainability may be kept open.
You're fixing it for admission, you raise whatever else you want.
case, the respondent number 4 has filed affidavit and we are filing our, my lord, rejoinder, my lord, it's ready, my lord, we are filing tomorrow.
Counsel for the petitioner submits that they file the rejoinder within this week and has prayed that the matter be listed next week.
On my lord 17th, my lord, because our.
On
affidavit is
17th. Accordingly, matter be listed on 17th, along with the rejoinder to be filed by the petitioner within this week.
48, 49.
Similar.
Yes.
Right. 48, 49 also listed on 17th along with 47, item number 1. None appears for the petitioner. Mr.
A. Burman for Planning Council.
A. Burman for the respondent. You filed your objections.
My lord, here we are contesting.
Have you filed your objections? Your file.
Yes.
Your objections, preliminary objections have been filed. Ah.
It's for the petition.
Ah.
Pleadings are completed.
Pleadings are completed. All right. Let the matter be listed the first week of September.
Date, my lord.
Second, 3rd of September.
My lord. I was here, my lord.
48, 49 SK mainly appears for the respondent principal. What accountant general? Accountant. Yes.
The application for appointment to arbitration.
For any objections? No objection. No objection.
It has come to mediation, right?
Huh?
The column of mediation, right? That has come.
Mediation. Oh, you want to go for mediation?
They say two brothers, they are both fighting.
Therefore mediation.
Therefore mediation.
All right. The parties are agreeable to make an attempt to resolve this matter through mediation. Accordingly, the parties will appear before the Gauhati High Court Mediation Center on 28th of August.
Yes, maybe so. This is the construction of a building, my lord. It's all stopped now.
28th of August. Or you want an earlier date?
The earlier date.
24th of August.
My lord.
24th of August.
Grateful.
None appears. Matter be listed.
I'm for the respondent.
MS Mr.
K. Polita.
A. Polita appears for the respondent. This is for mediation on Friday. It's on Friday.
May I please? Both the items are similar, Lordship. Only thing is item number 53, Lordship. They are retired employees of some higher secondary education council, and in 54, Lordship, they are working, still working. Matter pertains to non-payment of salary at the ROP prescribed rate. Lordship, petitioner are retired employees of some higher secondary education council. They have worked in various posts. Last while they were working as superintendent, they were promoted to the post of assistant secretary.
You are now petitioners that are working in which post?
Assistant secretaries.
assistant secretary
Yes, Lordship.
by way of promotion.
Yes, Lordship. They
And
were,
the direct recruit, there are some direct recruits.
yes, Lordship.
So there is a disparity between the pay.
Yes, Lordship. That is the.
What does the rule say?
There are two flag month, Lordship.
The pleadings are complete.
Yes, Lordship.
Then let us keep it for a hearing date for some time. Submitted before the court that the pleadings are complete. Matter be listed for hearing on when?
First week of September.
Second week. Second week of September.
8th of
10th. 10th of September.
September.
Okay. Both the matters. 10th of.
Could I perhaps be taken up at 2 o'clock? My Donald friend is still on legs before
2 o'clock.
School
will not under the Lahori Ghat block to the Mayang, another school at Mayang block. But this is a case where the petitioner in the school with the petitioner is working. There are 3 teachers and 107 students. And as per the RTA Act, the norms are that there should be 4 teachers. In fact, 1 teacher is short. Now I am being sought to be transferred to another school, which has only 17 students and two teachers. And the post against which I have been transferred, Lordship will see the transfer order.
Instructions.
Page 17.
You have? Monday. Monday.
Till
Get
then,
your instructions on Monday.
Till then,
Till no coercive action.
Because my order is of 1/8/2026. My parents pay 17.
Yes, it was served. I have made a specific
They did not
statement.
approve the authority, madam. They're approving the authority.
No, I have approached the authority, page 14, page.
What would the authority do if they he submits that it has violated his?
There is no violation, madam, because my parents is the sign of the act, madam.
Which act is it?
The Assam Elementary and Secondary School Teachers Regulation of Posting and Transfer 2020, madam. Section 9, madam. And if you
What
also
page number is this?
15, madam.
15.
15 months.
15.
This order is in page number 17 is issued, madam, in the public interest, madam. It is written here, madam, in the interest of public service, madam.
Oh, correct. Public
And-
interest, but if there is a ratio to be maintained, you maintain it.
Madam, may I read, madam, section 9, madam.
Section 9.
Section 9 of the, madam, act.
Section 9 is 8.
Madam,
3 and 4 are the relevant sections. 3 and 4.
You are reading, oh, sorry. Said page number 15.
1/5, madam.
15. Section 9.
Section 9, power of the deputy commissioner. In the exigencies for maintaining of the proper academic atmosphere in the school or for maintaining the peace and tranquility or secured of the female teacher, the deputy commissioner of the district, after observing such formative as may be prescribed, if satisfied the transfer of a teacher is essential for anyone of the state ground, may refer the competent authority for transfer of a teacher, even from a low PPR school. The competent authority shall immediately consider the proposal of the deputy commissioner and recommended the concerned appointing authority for issuance of transfer order.
Now you look on the section 10. Come to section 10.
This is in general transfer, madam. The extension of service, madam, deputy commissioner has the power, madam. Maybe, madam, on the recommendation of the deputy commissioner, madam, this order has been.
Maybe, madam. This has not been done. First of all, Lordship, can you see section 3 and 4?
No,
madam?
see, not just exigencies of service. It is exigencies of maintenance of proper academic atmosphere. Means that there is some problem with the teacher, is created some discomfort. therefore it is necessary to transfer him out to maintain the proper atmosphere for maintaining peace and tranquility. Again, relatable to the first condition. Or safety or security of a female teacher, which is not the case here. These are the three grounds on which the DC can recommend transfer. Mayor putting that exigency of service, it is not a regular transfer. Regular transfer,
For my lord, exigency of service, my lord, section 15 of the 2020 Act is my lord relevant.
but we're referring to this act,
Right.
showing us the power of the DC.
Right.
Power of the DC is restricted only in these three categories. And this is qualified by section 10, see. Section 10 is for a teacher on which grounds you may ask for transfer. So get your instruction. Heard counsel, Mr. M. Dr. Senior Counsel. Directly in the order dated 1/8/2026 with the petitioner is posted in so-and-so school in Morigaon has been transferred to another school within the same district. According to the petitioner, the school from in which the petitioner was working has been school where there is a high PTR.
Well,
high PTR to low PTR.
No, well, here, low PTR.
Low PTR to high PTR.
Sorry, high PTR. High because the number of students are more, teachers are less. So the high PTR.
High PTR. People teacher ratio. And notwithstanding this, the petitioner is transferred to a low PTR. So, being agreed, petitioner is referred to, has filed an application before the Director Elementary Education.
My lord, they have not prepared, my lord.
Yes, I have prepared.
On
My lord,
7/8/19.
my lord, 20, my lord. They have registered post on 7/8/2026, my lord. 1 day before filing this application, my lord.
Because it was served on 6, my lord. I filed on 7.
However, petition to order, where I am as Sutia Learner, Standing Council Elementary Education submits by referring to section 9 of so-and-so Act of 2020 that the Deputy Commissioner, the Deputy Commissioner is authorized to transfer in exigencies of service and therefore not issue. Deputy Commissioner is authorized to recommend for transfer exigencies of service and accordingly petitioner was transferred.
In that case, my lord may refer also by the section 15 of the 20 rules. There, my lord, in case of my lord, school within the district, my lord.
Yes. It is further submitted that this transfer is not intra-district, but within the same district. Therefore, there cannot be any grievance. That transfer is sought to be made out by the court, by the respondents. What rules?
Some elementary and secondary school teachers regulation of posting and transfer act 2020.
No, that act I've seen. Is there a set of rules also?
Yes, my lord.
Under the said act?
My lord.
What is the name of the rules?
My lord, Assam Elementary and Secondary Teachers Regulation of Posting and Transfer Rules 2020. Section 15(1), my lord. Dissemination, shifting and transfer of teacher, tutor, administrative expenses.
Probably are not here.
Okay.
Further submitted that under the rules.
And if your lordship
Frame.
may use para 14, my lord.
Connection of the say statute. What does the rule say?
Says, my lord, may read, my lord. In case of a school within the district having single teacher, tutor or no teacher, tutor or shortage of teacher, tutor due to any reason, circumstances at any point of time in any elementary or secondary school, the respective district elementary education officer or inspector of school or any administrative school authority shall within a period of 36 hours with the approval of the deputy commissioner of the district shall transfer and post required number of teacher, tutor to through that single teacher, tutor, no teacher, tutor or shall maintain prescribed pupil teacher ratio in elementary education, in elementary school or teacher, tutor in a particular subject as well as pupil teacher ratio as per the norms of the secondary school manual. The exercise rationalization of teachers will be done throughout the year on the need basis. If a lordship parents para 16 madam.
Submitting that. Who is permitted? The director.
Madam, any authority madam with the approval of the deputy commissioner. The district elementary education officer madam.
District elementary officer. Well, of the deputy commissioner of the district. Right. But here it is the transfer order by the director.
Director, madam, deputy district elementary education officer or minor inspector school or any administrative school authority.
The director is otherwise competent, it doesn't require the permission of the DC. This is in respect of the lower officers, who are not the controlling officer.
As per this minor approval of the deputy commissioner.
Only if it is transferred by these officers. And what paragraph you are referring to?
Minor may parents para 14 madam, page 8. The petitioner were the
Randomly picked up. Para 14.
para 14 madam.
Oh.
Minor randomly picked up for transfer without being any accidental service. Not only has the PTR norms of the school where the petitioner is serving.
You get your instructions. There.
Because at that school there is no teacher madam. That is my
Get your instructions. What are the reasons why they have been transferred? All these reports will be there. We get your instruction. Therefore, the urgency expressed. The stage with the State Council complete the instructions in the matter as to the ground on which the writ petition was transferred. Let these instructions be placed on 17, 18, which date? 17th of August. And matters be listed as a fixed item. In the next date of listing, no coercive action be taken on the petitioner in terms of the impugned transfer order. Same order.
Same order.
Same order in item 1, 2, and 3 of production.
And on item 56 also. Of the minutes.
This is for
55,
56 also.
56 also. And below 1. Biplab brush.
55, 56, and
Biplab.
yes.
Item 39.
Perhaps recall this particular matter has been further at length by our lordships. We have assailed the disciplinary proceedings which have been initiated against the petitioner and the action of the authorities. I am placing before your lordships a small. In fact, on the last occasion, I had given a copy of this, but it's not there in the file way. I had also given a copy to my learned friend in the last occasion. These are just the brief facts and the grounds on which I have assailed this particular proceeding, your lordships. So, the petitioner before your lordships has been given the major penalty of compulsory retirement. And we have assailed that penalty order along with the entire disciplinary proceeding. What had happened was, your lordship, there was a complaint filed against the petitioner saying that he had sexually harassed two girl students in the university. And one of the grounds is the non-supply of relied documents, as well as the evidence which were taken by against the petitioner. What they have, the entire disciplinary proceeding, what has happened is that they have neither given me a chance to cross-examine the witnesses, nor have they given me the relied upon documents. That is the specific case of the petitioner, that even in the memorandum of charges, the list of documents which was annexed was never furnished to me. The copy of the initial complaint was never furnished to me. I was made to read the complaint once when the ICC was sitting at one particular point of time.
Sexual error.
Then the fact that during the inquiry itself, after the inquiry was completed, a copy of the inquiry report was also never furnished to me, Your Lordships. So that on those grounds, we had come assailing the entire proceedings. During the pendency of this writ petition, they have now brought the inquiry report on record by way of filing an affidavit in opposition. Your Lordships had also asked for petition of the records, which have also been placed before Your Lordships. And in the meanwhile, the statutory violations which I am relying upon, if Your Lordship will kindly come to page 4 of the compilation which I have just given. These are the various statutory violations which have happened during the entire proceeding. I'm just going in a nutshell, Your Lordships. Firstly, so many rules of the Central Civil Services CCA rules have been violated, specifically Rule 14.4a, 14.17 and Rule 15.2. I'm heavily relying upon Rule 14.4a and Rule 15.2, Your Lordships, that these two have not been complied with. Secondly, Your Lordship will take up the next page, page 5.
Yeah.
There is an office memorandum which is issued by the
Yes.
should I take Your Lordships to 14.4a first before I move on with the office memorandum? Yes, Your Lord. 14.4a very specifically says that the disciplinary authority shall deliver or cause to be delivered to the government servant a copy of the articles of charge, the statement of imputations of misconduct or misbehavior, and a list of documents and witnesses by which each article or charges is proposed to be sustained. Now, this is the specific stand which I have taken in the writ petition, that they have never furnished me with the list of documents which they had relied upon. In fact, the initial complaint itself was never furnished to me, Your Lordships.
Yes.
Then thereafter, if I may take Your Lordships to 14. Okay. 14.14.
Yes.
On the date fixed for the inquiry, the oral and documentary evidence by which the articles of charge are proposed to be proved shall be produced by or on behalf of the disciplinary authority. The witnesses shall be examined by or on behalf of the presiding officer and may be cross-examined by or on behalf of the government servant. Now, this opportunity was also denied to me.
You're referring to
Article, Rule 14.14.
14.14.
Yes, sir. So, the cross-examination of witnesses was also denied to the petitioner. Then 14.17. The evidence on behalf of the government servant shall then be produced, and the government servant may examine himself in his own behalf, if he so prefers. The witnesses produced by the government servant shall then be examined and shall be liable to be cross-examined, re-examination, and examination by the inquiring authority, according to the provisions applicable to the witnesses for the disciplinary authority. Now, this, although I had submitted a list of my witnesses, I was never made aware whether my witnesses were ever called, because if they were called, they were not called in my presence. So I am not aware whether this list of documents or the list of witnesses which I had submitted were ever examined or whether they were even called for examination. This is also another lacuna in the proceedings. Then Your Lordship will kindly come to 14.21. It basically says, Lordship, to cut it short, what it says is that the entire records of the inquiry shall be given to the disciplinary proceeding. This is not so much applicable in our case. I would rather take Your Lordships to Rule 15.2. If Your Lordships may kindly take up for a moment. Rule 15.2.
15.2.
Yes. 15 is action on the inquiry report. I'm reading 15.2, Your Lordships. The disciplinary authority shall forward or cause to be forwarded a copy of the report of the inquiry, if any, held by the disciplinary authority, or where the disciplinary authority is not the inquiring authority, which is not in our case, Your Lordships. The report of the inquiring authority, together with its own tentative reasons for disagreement, if any, with the findings of the inquiring authority on the article of charges to the government servant, who shall be required to submit, if he so desires, his written representation on or submission to the disciplinary authority within 15 days, irrespective of whether the report is favorable or not to the government servant. This opportunity has again been denied to me. The inquiry report was never furnished to me. They have directly imposed a punishment of compulsory retirement by placing the inquiry report before the Executive Council. That is my humble case before Your Lordship. Now, the other statutory violations, insofar as their own office memorandum, there is an office memorandum of the DOPT, Your Lordships, which Your Lordships will get at the affidavit in opposition filed by the respondent numbers 2, 3, and 4, annexure 7. This is at page 170 of the pleadings. Clause 7 of this page, page 172, the effective portion of it. I'm reading clause 7, need for investigation, from page 172.
Yes.
Got it? The complaints committee may act on complaints of sexual harassment when they receive them directly or through administrative authorities, etc., or when they take cognizance of the same suo motu. As per section 9(1) of the Act, the aggrieved woman or the complainant is required to make a complaint within 3 months of the incident. Now, this complaint is more than 6 months old, Your Lordships. So, it is required to make a complaint within 3 months of the incident, and in case there has been a series of incidents, 3 months of the last incident. The complaints committee may, however, extend the time limit for reasons to be recorded in writing. Now, this is something Your Lordships will perhaps have to verify from the records, whether any such, because I was never furnished with anything of the inquiry, so I am not aware whether they recorded any reasons.
Is it a mandate of the statute?
Yes, Your Lordships, it is.
Let's see the statute.
Of course, it is a flexible this thing. The Act itself says that the authority may can condone that delay. It is 9(1), Your Lordships, complaint. Any aggrieved woman, may I read 9(1)? Yes. Any aggrieved woman may make in writing a complaint of sexual harassment at workplace to the internal complaints committee if so constituted, or the local committee, as in case it is not so constituted, within a period of 3 months from the date of the incident. Now, this is an incident which supposedly one incident has occurred sometime in the month of May 2024 in this particular case. And they have filed the complaint sometime in late November, Your Lordships. So, whether the ICC has recorded its reasons for allowing her to file this complaint 6 months after the incident, if not 6, at least 5 months after the alleged incident has taken place. That is something that only the records can reveal, Your Lordships. This is the first violation which I'm talking about. Then, if Your Lordships will kindly take up clause 16. So 16, 17, Your Lordship, these are all the stages of the inquiry, and how whatever I have just produced before Your Lordships, insofar as CCS is concerned, the same has been brought in by way of this OM as well. So 16 is talking about the inquiry of authority is thereafter required to ask the presenting officer to have the prosecution documents listed in the charge sheet inspected by the charged officer. Even this was disallowed, Your Lordships. So the entire list of documents which they have themselves relied upon was never given to me. Yes, I was allowed to go through the complaint once during one of the ICC proceedings. I was made to read the complaint. I do not even remember what the complaint was, Your Lordships. Then, if Your Lordship will come to page 174, at clause 18, this is examination of witnesses, Your Lordships. Same thing which I have just read out in CCA rules has been put across in this OM as well. Somewhere in the middle of clause 18, the examination in chief would be done by the presenting officer, where the presenting officer may ask questions of the witness to ascertain the facts. The witness would thereafter be cross-examined by the defense After the cross-examination, the presenting officer would be given an opportunity to re-examine the witness. So this 18 has been violated, 19
But
again.
Why did you prefer an appeal? Against the appeal for?
Lordships, how could I have appealed? The inquiry report was never given to me. The provision
When
of
did you
appeal
receive the inquiry?
from the affidavit in opposition filed before this honorable court. And now it is sub judice in any case. And the appeal, in any case, I am challenging the entire disciplinary proceeding because I was never allowed to even cross-examine the witnesses. That is a gross violation of the principles of natural justice as well as statutory violation, Your Lordships. The UGC also has filed an affidavit. I will just take 2 more minutes of Your Lordship's time. So apart from these various clauses which I have talked about in page 5, I will just take Your Lordships to the affidavit filed by respondent number 5, UGC, at annexure B, page 275. This is the vernacular version, and the Lordship will get the English version at page 284. 284 units. This is the notification of the UGC of 2016 and how ICC proceedings are to be conducted in the higher education institution. I will take Your Lordships to page number 290. Clause 7. The process of making a complaint of sexual harassment. An aggrieved person is required to submit a written complaint to the ICC within 3 months from the date of the incident. Again, Your Lordships, this has been reiterated on by way of 2 different OMs. And in case of series of incidents with which we are not concerned with, then Your Lordship will kindly read the proviso of this particular clause. Second proviso, provided further that the ICC may, for the reasons to be accorded in writing, extend the timeline not exceeding 3 months if it is satisfied that the circumstances were such which prevented the person from filing a complaint within the set period. So the same power has also been given to the here by way of this OM, saying that the ICC certainly has the power to grant extension of 3 more months. However, reasons have to be accorded and recorded in the inquiry itself. Now, this, Your Lordships, had allowed us to have a look at the records, and this reason was never in on the last occasion when Your Lordships had perused the records. Then clause 8, Your Lordships, process of conducting inquiry. The ICC, upon receipt of the complaint, shall send 1 copy of the complaint to the respondent within a period of 7 days of such receipt. They have sent me a copy of the memorandum of charges without the complaint, Your Lordships. I have been reiterating it is the specific stand of the petitioner that the complaint has never been furnished to me. Then clause 3 of subclause 3 of clause 8. The inquiry has to be completed within a period of 90 days from the receipt of the complaint. The inquiry report with recommendations, if any, has to be submitted within 10 days from the completion of the inquiry to the executive authority of the higher education institution. Copy of the findings or recommendations shall also be served on both parties to the complaint. A direct violation of this clause 7 and clause 8 also. Again, clause 4 also, subclause 4. The executive authority of HEI shall act on the recommendation of the committee within a period of 30 days from the receipt of the inquiry report, unless an appeal against the findings is filed within the time frame of by either party, and the time frame for filing an appeal is 30 days, which is in clause 5, subclause 5 of clause 8. So all of these statutory violations simply reveal that the entire inquiry proceeding which has been held against me is an eyewash, and I was very gravely prejudiced by not allowing me to either cross-examine my witnesses or any of the prosecution witnesses also, Your Lordships. In which case, in my respectful submission, I'm not bothering Your Lordships with case laws. There are several. I'll be obliged if Your Lordship will allow me to.
Where are your witnesses? Where have you listed your witnesses?
Just one. Page 40 of clause. Page 40 of the affidavit of opposition, Your Lordships. This one. There's a specific page in my petition where I have. Just give me one.
In your reply, you do not furnish it.
in my affidavit in reply. Yes, Your Lordships.
No.
Huh.
Reply file for the authorities.
Yes, page 54, Your Lordships, of the writ petition. This is in this is Annex to B collie of the writ petition. If Your Lordship will kindly turn to page 53 for a minute. 53 Annex to B collie. Got it? Towards the center of the page, you also will find ICC Assam University Silchar, dated 3rd December 2024 at 10:49 a.m. They have sent it to me. This is, I'm just reading this thing. Dear Dr. Kumar, this is to inform you that 2 of your department students have lodged complaint to ICC regarding your inappropriate behavior to them. You are hereby requested to appear before ICC tomorrow. So very next day, I've been told to appear at 3 p.m. Venue is the Department of Physics, AU Silchar campus, to put forward your views of the matter. Now, I stay in the DFU campus, Your Lordships. I'm given 1 day's time to go to the Silchar campus. In any case, Your Lordships will come to the next page for a minute at page 54. When I went and appeared there, they said, give us your reply.
No, on the day you were served,
yes, Your Lordship.
You were called for.
No, this is before the serving of memorandum of charges.
Before the serving.
This is before the serving of memorandum of charges. Then they called me. This was a preliminary inquiry, perhaps. And in the preliminary inquiry, they said, do you want to rely on something? It was all verbal, Your Lordships. Everything was verbal with me. So then on 5th of this next page, page 54, Your Lordships will find that in the center of the page, on 5th of December, I have sent this whole list of my witnesses to them. I have mailed it to them. And after that, if anything, if they have acted upon this, I am not aware of it, Your Lordships. Then thereafter, I was placed under suspension, which I again had to challenge before this honorable court, because my suspension was extended without recording any grounds in it. Then once the this honorable court allowed
at the conclusion, you were compulsorily retired.
Yes, Your Lordship. That is under stay as of right now by virtue of Your Lordship's order, but only to the extent that that will not be given effect. So I have not been given any benefits, or I'm not. So since October last year, the impugned order.
What is the extent of the respondent? We'll come back to you. No, I mean regarding the allegations that these procedures which are mandated.
I produce the record before Your Lordship. Admittedly, Lordship for consequence done by the the witnesses. Does not cross-examined by the petitioner. That is no cross-examination. My humble submission, Lordship, for Lordship may direct the university, conduct the inquiry from where it has been found.
Yes, private respondent, complainant. What do you say? What is your stand? No, the allegation is that the inquiry presence in the campus.
Lordship, that is absolutely correct. I completely agree with that. The respondent number 6 is a PhD student. She was under me. I was her guide. Now, in the meanwhile, during this entire 1.5 years, she has already changed her guide, and there is no occasion for me to even meet her. And the other respondent number 7.
In the fitness of things, you should be kept under suspension. It's only a matter
Lordship,
of 3 months or whatever.
Not in that case, if under suspension, my suspension allowance may be kindly be given to me.
Of course, it will.
That observation may
That
kindly be
subsistence allowance will have to be given.
Lordship.
And you are staying in the campus, within the campus.
No, outside. I do not.
So you completed, how much time would you require? 3 months. Complete it within 3 months, follow all the procedures. And whatever area salary or whatever is there, you release, and the petitioner will be treated to be under suspension during the period, subject to payment of whatever. And the petitioner will have to be given all opportunity to
strictly as per the UGC guideline.
You will share your number and email with the authorities.
Not should they have it? Of course, I will.
So that there should not be an occasion that you did not get informed.
No, they're aware of mine. I will certainly share as well. Possibly kindly quash the order impugned in the writ petition. Of course, your lordships have already said so, that I will be reinstated. So that prayer was for quashing of the compulsory retirement order, which perhaps will consequentially. That page number 133 of the writ petition.
Third, when it comes to the parties, this writ petition is directed against the impugned order. Where is the order?
Page 133 of the writ petition, your lordships.
31/10/2025, whereby petitioner was imposed punishment of compulsory retirement under Rule 11, Roman 7, CCS, CCA Rule 1965 as a major penalty. The basic facts required to decide the matter are that the petitioner was employed as a what professor?
Assistant professor in the Department of Hindi,
Assistant professor as a department of
Assam
the
University,
Assam
Difu campus.
University, which is a central university established by an act of the parliament and was posted in the Difu campus.
Yes,
the district of Kaviyangaon. While the petitioner had been rendering services as a professor, assistant professor, two students, female students, lodged complaints of sexual harassment against the petitioner. Before whom?
Before the ICC.
Where are the complaints?
I do not have them. I was never given a copy of the complaint.
Last topic the notified provided.
Complaints were filed before the competent authority, pursuant to which notices were issued to the petitioner. Upon preliminary inquiry being made, the show cause notices dated. Where is the show cause?
No, the memorandum of charges.
Memorandum.
Yes.
Where is that?
Dated 21/2/2025. You'll also find it at page number 56.
The memo charges dated 12th February 2025. Stop. The memo charges included the article of charges. Three articles of charges, and it's also statement of imputation of mental harassment of the female students in the educational institution. Stop. The memorandum also included the list of witnesses and the list of documents proposed to be relied upon the inquiry proposed against the petition. Stop. Petitioner thereafter communicated with the respondent authority that the relevant documents have not been enclosed.
Page 62.
Stop. According to the petitioner, these documents were never handed over prior to the inquiry being proceeded with. So, the inquiry thereafter was conducted by the ICC in complete violation of the procedure prescribed under the CCS rules, read with the Sexual Harassment of Women at Workplace Prevention, Prohibition, Repressal Act, as also the UGC guidelines for the notification. So, thereafter, by the impugned order dated so and so, the punishment of major penalty of compulsory retirement was imposed. So, the learned counsel appearing for the petitioner submits that there are glaring irregularities noticed in the manner in how the inquiry was conducted. Firstly, the complaints were lodged beyond the period of 3 months, and as mandated under the Act of 2013, if complaint is to be entertained beyond the period of 6 months, then such complaints cannot be entertained without reasons being recorded. So, there was some settlement also, is it? It is submitted that the witnesses were never cross-examined by the petitioner, and the defense witnesses which were listed, list of which was forwarded by the petitioner, were never called, or even if called, the petitioner is not informed whether they were examined. Stop. In other words, these witnesses were never examined in the presence of the petitioner. Stop. A copy of the complaint, although shown to the petitioner, was never handed over. Submitted that the UGC has laid down detailed guidelines as to how such inquiries are to be conducted. Where are the guidelines? UGC 290.
They are 2nd May 2016, you know. Starts at page 284. The relevant portion is at page 29.
Guidelines were brought into effect through the University Grants Commission Prevention of Prohibition Reversal of Sexual Harassment of Women Employees and Students in the Higher Educational Institutions (close) Regulations 2015. The Learned Counsel has elaborately referred to the guidelines to submit that there are specific provisions, particularly under Regulations 7 and 8, laying down the process as to how complaints are to be entertained and inquiries are to be conducted. So, a perusal of these processes laid down clearly reveal that the procedure adopted by the petitioner has been completely flouted by the respondents. So, the further reference is made to 14 of the CCS rules, 14 and 14A.
14.4a.
14.4a. To submit that the CCS rule, which is adopted by the respondents, also clearly provides the manner in how the inquiry is to be conducted. And these rules are also not adhered to by the ICC in the inquiry conducted against the petitioner, and therefore the conclusion derived from the inquiry report is violative of established rules and procedure. So, under such circumstances, the petitioner before this court praying for interference and setting aside of the order dated so and so passed against the petitioner, and a further order for reinstatement service. So, par contra, Mr. SCKL, Senior Counsel, appearing for the university, has disputed the contentions raised by the petitioner by filing their affidavit. The respondents have disputed the various contentions raised regarding non-adherence to procedure prescribed. Mr. KL, in all fairness, submits that the records which were produced before the court did not reveal that any opportunity was granted, did not reveal, did not record any finding by the ICC as to when and how the petitioner was given an opportunity to examine witnesses, or whether the witnesses, including the defense witnesses, were examined in the presence of the however disputes submission of the respondents that copies of the complaint were never furnished. It was furnished, you admit?
No,
No, sir, it was never.
No, copy not furnished.
no, we said that we take furnished to the.
Huh?
Come with the charge sheet, all documents have been furnished to the.
Therefore, you dispute that submission.
Of the
However, dispute submission.
of the petition.
Huh?
Submission of the petition. The officers have recorded that he disputes the submission of the respondent.
Submissions of the petitioner, then the copy of the complaint was never furnished. Submits that along with the memorandum, copy of the complaint was also furnished. Considering the submissions made, the records were called for. Mr. S. Sarkar appears for private respondents were arrayed as parties pursuant to an application for improvement sought for by the persons, by the complainants. So, Mr. Sarkar, on his submissions, as referred to the affidavit filed, he submits that the inquiry was conducted as per, it's required to be conducted as per the rules. And therefore, the students, the complainants, the prayer for interference with the order ought not to be interfered with, ought not to be granted. Ms. Agarwal, appearing for UBC, submits that by their affidavit, they reiterate their stand, which is reflected in the so-and-so regulations of 2015. These regulations are still in force and has not been recalled. And considering the educational institutions, all instructions and regulations issued by the UGC are binding and mandatory so far as institutes of higher learning are concerned, including the respondents. Learned counsel for the parties have been heard. It will on record and be carefully produced. Records which were called for and the case before the court on the last date were also provisions of the so-and-so Act of 2013, which are relevant for the purposes of this proceedings, are extracted below. Section 9, Section 11, Section 13. Procedure prescribed under the CCS rules, which is stated to be adopted by the respondent, also required to be referred to. 14 lays down the procedure for imposing penalties. A, 14.4a lays down the following provisions. 14.4a, 5a,
Four A. 14.4A.
yes, 14.4a and 5a.
No, 15.2. I've also referred to rule 14 and 14.17.
So we are referring to 5a.
Oh, I apologize.
14.5a and 14.14, 14.17. So rule 15. Stop. So and so regulations 2015 framed by the UGC. Also required to be referred here at this stage. 7 and 8, regulation 7 and 8 of the said regulation is expected below. So, upon perusal of the record which I produced, has also and upon consideration of the submissions made, particularly submissions of the learned counsel to the respondent who fairly submitted that the records do not reveal indicate as to whether the witnesses were examined by the petitioners or in the presence of the petitioner. It's clear that where proceedings are initiated against a delinquent employee, more particularly which culminates in imposition of major penalty, procedure prescribed by law is to be strictly adhered. Procedure as to how the inquiry is to be conducted is laid down the CCS rules. Pursuant to the enactment of the Act of 2013, CCS rules prevent an amendment and power is given on the ICC make the necessary inquiry and pass appropriate orders including of major penalty. Separate inquiry required for imposition of penalty cases with sexual harassment alleged delinquent officer. So in such circumstances, the ICC is required to follow the rules laid down under CCS rules, as also by the statute, which is the Act of 2013. So that apart, the respondent authority being Institute of Higher is a university, Institute of Higher Learning, are governed by the are required to strictly follow the norms, the guidelines, the regulations issued by the UGC from time to time. Context of sexual harassment is framed the so and so regulations, which also clearly replicates procedure prescribed under the CCS read with the Act of 2013, which has been extracted above. Under such circumstances, question before the court is the non-furnishing of inquiry report as also the procedure violated was prejudice to the delinquent employee, which will call for interference with proceedings initiated. Stop. Are you carrying any documents?
Yes, no, so it's in that piece of paper which I have.
Piece of document where
That document I have all the points that I relied upon, each point, every judgment that I am relying upon. For non-supply of relied upon documents, page 1.
the counsel for the petitioner has relied upon the following judgment, support of contention. Required have to be referred to the stage.
For non-supply of relied upon documents, Kashinath Dikshita and in state of Maharashtra, MP versus Chintamani. And the paragraphs which I'm relying upon also have been quoted. Then insofar as witnesses is concerned, evidence of witnesses, that's Union of India versus T.R. Verma and Aureliano Fernandez versus State of Goa. and non-supply of inquiry report again to Managing Director ECIL and Mohammed Ramzan Khan.
So and so versus so and so. Question of folk documents was explained by the Apex Court. When that mere production of documents before the inquiry committee not sufficient documents. These documents have to be manner prescribed under the Evidence Act, and particularly where the documents relate to a particular witness, then the presence of the witness, the examination of the witness, respect of the document is mandated. So that was so and so versus so and so. Ray Aureliano Fernandez, the Apex Court has explained in the get detail, procedure to be prescribed. Inquiries which are conducted on the basis of complaints. Under the Influence of Sexual Harassment Act. Relevant paragraphs are extracted below. Judgment get only. So, considering issues involved, then upon perusal of see that there are lacunas in the procedure. It was adopted by the ICC while conducting the inquiry and concluding of a major penalty by compulsory retirement of the petition. So, celebrated judgment of the Apex Court rendered in CIA. Says so and so. Karunakar reported in 1994 SCC 727 has laid down that non-supply of the inquiry report. The serious lacuna which will prejudice delinquent employee. You know the reasons as why. As to the conclusions arrived at by the inquiry officer. So, is there a procedure that after conclusion there has to be a further notice before imposition of the punishment?
That's provide.
Huh?
CA provide that second book will not be
Necessary. Under what rules?
After Mohammed Ramzan Khan, that has become mandatory.
No, but the rules will have to prescribe that.
Your Worship 15.2, the one which I was referring to, action on the inquiry report. 15.2 specifically says that the disciplinary authority shall forward or cause to be forwarded a copy of the report of the inquiry, if any, held by the disciplinary authority, together with its tentative reasons for disagreement, if any, with the findings of the inquiry authority on an article of charge to the government servant, who shall be required to submit, if he so desires, his written representation or submission to the disciplinary within 15 days.
So, who is your disciplinary authority?
In this case, the ICC. The ICC assumes the role of a disciplinary authority.
Mandates of the Apex Court and the CIA. It's incumbent on the respondents to furnish a copy of the conclusion arrived at along with the tentative reasons, tentative reasons, if any, for disagreement on the delinquent officer, so that he may have an opportunity to persuade the disciplinary authority or against imposition of major penalty. So this specific procedure was not followed. Where the procedure prescribed by a statute not followed, not yet authority that is supposed to follow in terms of the statute, it does not reflect the procedural fairness required to be adopted by mandatory by the authorities concerned. Procedural unfairness would be an instance of arbitrariness for which this court there is another aspect of the matter that the Act of 2013 prescribes for an appellate forum, section so and so. So, according to the petitioner, no appeal would have been heard. The absence of any certified copy of the inquiry report being furnished on petition. So, such circumstances, it's clear that the procedure prescribed under law was not followed, thereby absence of the fair procedure itself is a ground which exposes the respondent authority rights of arbitrariness. Under such circumstances, this court is of the view that considering the gravity of the allegations made against the petitioner, matter stands remanded to the ICC to now you've got a copy of the complaint
Yes, to the affidavit of opposition.
to initiate the proceedings afresh by following the procedure prescribed under the statute of 2013, read with the rules, CCA's rules, and also the so regulations, UTC regulations. So the petitioner will appear before the ICC as and when informed. The contact numbers and the email addresses of the petitioner are available. Respondent authority. In the event of any change thereof, petitioner will intimate the university authority of such changes. Let this inquiry be conducted within a period of 90 days from the date of receipt of a certified copy of this order. Stop any such order, needless to say any such order that may be. Copies thereof shall be served on the petitioner. So, considering the fact that the matter has been remanded back to the city authorities for a fresh decision, the order of compulsory retirement is set aside, enabling the authorities to conduct the inquiry afresh as directed. So, meanwhile, petitioner, considering the allegations made, the petitioner will be placed under suspension, treated to be under suspension, and the authorities will ensure that the petitioner is not given a residence within the campus in which the complainants reside.
No, the complainants also don't reside in the campus.
And further, any area salary prior to the order of compulsory retirement, and also his subsistence allowance has been receivable, be released without further delay. Accordingly stands disposed in terms of,
Perhaps a new order of suspension may have to be issued, considering your lordship's direction. So
we have already directed them.
Yes, till
They will only
that
create, they
time.
will only